This courtroom hearing starts with a sentence that should make anybody stop in their tracks. You could be sentenced up to life in prison, and from that moment forward, you already know this isn't some routine probation check-in. This is a woman standing on the edge of losing everything. We're talking about a defendant already on deferred adjudication for aggravated robbery, a violent felony, now back in court after allegedly picking up new criminal charges involving drugs and theft. And the judge? She's clearly running out of patience. But here's where this case gets complicated. Because underneath the criminal history, the violations, and the repeated mistakes, there's also addiction, toxic relationships, relapse, and a woman trying to convince the court she still deserves one last chance. The prosecution is basically saying, enough is enough. The defense is arguing that prison won't solve the root problem, and the judge is caught balancing public safety against rehabilitation. Pay attention to how the tone of this hearing shifts. At first, it sounds procedural and routine, just another revocation hearing. But the deeper they dig into her history, the more personal this becomes. You'll hear discussions about drug addiction, abusive relationships, employment struggles, relapse triggers, and whether someone can truly rebuild their life after serious criminal charges. And one thing you're definitely going to notice? The judge isn't just listening to words here. She's studying attitude, accountability, and mindset. Every answer matters. Every hesitation matters. Even one small comment later in this hearing completely changes the atmosphere in the courtroom. So the big question becomes, is this a woman genuinely trying to recover and change her life, or someone who's simply run out of excuses? And when the judge finally gives her two life-changing options, the response she gives may surprise you. Stay locked in, because this hearing takes several emotional turns before the final ruling comes down.
Do you understand by pleading true to violations 1 and 1, the court could find it true, grant the motion, find you guilty, and sentence you up to life in prison and up to $10,000 fine? Court is calling 2020 CR 9. Oh, I'm so sorry. Court is calling 2020 CR 9874B, State of Texas versus Keisha Smith. Could I have parties announced for the record for the state?
Brian Grimmer for the state of Texas.
For the defense?
Albert Childers, Your Honor.
Are you Ms. Smith? Showing you what's entitled motion to enter adjudication of guilt and revoke community supervision. Did you review that with your attorney? Did you understand it? Are you the same Keisha Smith who was placed on deferred adjudication in 2020 CR 9874B for the offense of aggravated robbery on February 25th, 2021 for a period of 5 years? Is that you? State?
Okay. Violated condition number 1, on or about the 30th day of September 2022. In Bexar County, Texas, the defendant Keisha Smith committed the offense of possession of a controlled substance in violation of condition number 1.
How do you plead, true or not true?
Violated condition number 1, on or about the 30th day of September 2022. In Bexar County, Texas, the defendant Keisha Smith committed the offense of theft in violation of condition number 1.
How do you plead to that, true or not true?
We've waived the remaining conditions.
Any objections?
No objection, Your Honor.
Did you understand by pleading true to violations 1 and 1, the court could find it true, grant the motion, find you guilty, and sentence you up to life in prison and up to $10,000 fine? Knowing that, do you still wish to plead true to violation of conditions 1 and 1?
Right here is where the danger level in this hearing becomes very real. Once Ms. Smith pleads true to those probation violations, the court no longer has to prove the allegations through a contested hearing. That's huge. In Texas, pleading true in a revocation proceeding is essentially admitting the violation happened, and now the entire focus shifts to punishment and whether the judge believes rehabilitation is still possible. And notice something else. The original charge here is aggravated robbery. That's not a minor offense. That's a violent felony. So when the prosecutor starts pointing out that she picked up new offenses while already on probation, the state's argument becomes simple. Why should the court trust her again? That's why prison immediately enters the conversation. But then the defense pivots toward treatment instead of incarceration. And honestly, this is where the courtroom battle becomes philosophical as much as legal. Do you punish addiction with prison, or do you attempt structured rehabilitation? Because the defense is basically arguing that the waiting period for treatment is the problem, not the treatment itself. And viewers, think about this carefully. If someone commits new crimes while already on probation, should the court prioritize accountability or recovery? That's the tension driving this entire hearing.
Court will find 1 and 1 true. Is there an agreement?
There's not, Judge.
All right, State, what are you requesting?
Judge, in this particular case, the recommendation of probation was state ISF. However, in conferring with the defense, she doesn't believe she wants to wait in custody for state ISF. So I think in this particular situation, she's on for a very serious violent felony, and she's picked up new felonies now. At this point, if she's not willing to go get that treatment and she doesn't want to wait in court or wait in jail until she can go to state ISF, then we believe the only remedy that we have would be for her to go to prison, for her to be revoked and sentenced to 5 years tease.
Defense.
And Judge, she is willing to do state ISF. The only issue is she doesn't want to wait 5 months in custody because of the backlog. There are several defendants that have been told it's a 6-week wait. Don't worry about it. It'll be, over before you know it. And they sit months and months and months waiting for a bed. I've talked to the state. My client would be willing to report weekly if she needed to while she's waiting for a bed. She wants the treatment. I will call my client just to,
No, I mean, I'll take your proffer. If you want to call your client,
You can feel the judge's frustration building here. The court keeps circling back to one issue. This defendant was already given a major opportunity through deferred adjudication, and instead of staying completely clean, she allegedly picked up 2 new felonies. That's the kind of thing that makes judges question whether probation is even working. But at the same time, notice how the hearing starts shifting from punishment into understanding the why. The judge begins asking about addiction, employment, education, and stability. That's not random. Judges often want to know whether someone's relapse is tied to deeper instability or whether the defendant is simply refusing to comply with the law. And honestly, her explanation about relapse is something courts hear all the time. People doing well for a period, thinking they've regained control, and then slipping back into old habits. Addiction cases are incredibly difficult because relapse itself doesn't always prove someone is hopeless. But courts also can't ignore repeated criminal behavior connected to that addiction. What's fascinating here is that the judge hasn't shut the door completely. You can tell the court is still evaluating sincerity. Is she taking responsibility? Is she making excuses? Is she truly willing to accept strict treatment conditions? Every answer is being weighed very carefully right now.
can. But the issue the court is having is that she's picked up 2 new felonies. And now people, are complaining about the wait.
Absolutely, Judge. And if I can may I
Yes,
call her?
yes.
Ma'am, could you please state your name?
You can raise your right hand. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God? You can lower your hand, state your name for the record.
Ms. Smith, do you realize how serious the case you're on probation for is?
I do.
Do you understand that, as the judge explained, when you're on probation for this type of case, if you're on deferred adjudication, you're subject to a full range of punishment for this kind of case? And yet, somehow, some way, you've been arrested for shoplifting. Is that correct? And it's been twice that this has happened. And one of the times you were arrested, you were in possession of some drugs. And why are you out shoplifting?
Basically, I've been on the probation for 2 years, and I wasn't legally I had a fallout with my parents, and I didn't have anyone to say. So when the only people that I knew was previous times, and when I relapsed and got back on drugs, which you could see, these cases all happened within a certain amount of time, and those were the times that I was usually hurt. Prior to that, I was perfectly fine if I was to be able to do like a sober living or get some type of support where I can't stay off of drugs. I know that I can be successful.
And let me ask you a question. How old are you right now?
I'm 35.
And, at any point, did you have a career?
Yeah, I do. I worked for Wells Fargo Bank for 7 years before you began. I worked for a pharmaceutical company, CVS. I'm currently in college for cosmetology and both, which can be confirmed through my probation. Which is another reason why, it's not that I don't feel like I deserve to wait. I understand that's better than going to prison waiting for the bed for I because I do want help, but I just really wanted to get back to school. And I know I should have thought about that before, but again, my mind wasn't where it should have been.
Okay, and let me ask you this, have you tried looking for work while you've been on probation?
I was working on the,
Okay, have you encountered problems because of your felony probation?
yes, the type of work that I'm used to is, it's a thinking or when I tried to get back into the game because of my record. It's honest. Like I get the job and then once the background comes, it's a little bit discouraging.
And you're on deferred adjudication probation. Do you understand that if you successfully complete it, you would not be convicted of the aggravated robbery? Do you understand that? And you understand that you could seek to seal your record. It would be an option that would be available to you.
Yeah.
This section of the hearing may actually be the turning point. The judge starts focusing less on the crimes themselves and more on whether there's a realistic path forward. And legally, that matters because probation isn't just about punishment. It's supposed to be an opportunity for rehabilitation under supervision. When the judge asks about long-term plans, sobriety, outpatient treatment, AA meetings, and willingness to comply with conditions, she's essentially testing commitment. Courts hear promises every single day. What judges look for is consistency, humility, and whether someone understands the seriousness of their addiction. And listen closely when Miss Smith admits that relapse taught her addiction isn't just a weekend party thing. That statement probably carried weight in the courtroom because it sounds like someone finally recognizing the permanence of the problem. Addiction recovery often starts with acceptance, and the judge seems to be probing whether that realization is genuine or temporary. But there's another layer here too: employment and deferred adjudication. The judge explains that successful completion could eventually allow her to avoid a formal conviction and possibly seal her record. That's massive. It means probation wasn't just keeping her out of prison, it was potentially preserving her future. So now the stakes are even higher. If she fails again, she risks losing not just freedom, but the chance to rebuild her life long term.
And has that been part of your long-term plan to be a productive member of society, to get back to some normalcy? And do you have a drug problem? And are you trying to address that problem? You need to speak up, I'm sorry.
Yes,
And are you trying to address that problem?
Yeah.
And are you willing to go in like state ISF?
Yeah.
Are you willing to do outpatient or NA meetings, AA meetings, that sort of thing?
Yeah.
And are you asking this court to consider that if she gives you a chance to continue on probation, are you willing to do whatever the court requires?
yes. Yeah, absolutely. I also, what I've learned from relapsing is I was naive into thinking, oh, well, that was just a moment in my life. That's not me. I'm not a drug addict, or it was just a phase. But after relapsing, now I know, and I do take into consideration how serious addiction is, and that it is not something to take lightly. It's not ever going to be just a weekend party thing for me, or it's a lifelong battle that I'm going to have to do. So I do take it seriously. That's just something I have to learn from relapse.
And if the court wants you to do zero tolerance or to go to state ISF, will you take it seriously? Is there any point in you going?
Yeah, absolutely.
And all of this happened. Were you married at some point?
I was, I am,
Okay. Are you still in that marriage?
I am, but we've been separated from you.
Okay. Why did you get divorced?
Infidelity on his part and, abuse.
Okay. Are we talking about domestic violence? When you first got arrested for aggravated robbery, were you in a relationship with a gentleman that was involved in that?
Yeah,
And was there domestic violence in that situation? Did he shoot you in the back of the head?
yeah,
Is this an issue you've been dealing with?
yeah.
Have you been in a relationship with a gentleman that was involved in the Walmart incident? Was there anybody there that was involved in that?
Yeah.
And is that a different person?
Yes,
So we're talking at least 3 people that you've been in a dating relationship that maybe haven't been the healthiest choice for you.
This part of the hearing becomes incredibly personal and honestly uncomfortable. The judge starts connecting repeated criminal behavior with repeated unhealthy relationships. Domestic violence, manipulation, instability, trauma, all of it starts surfacing at once. Now, to be clear, the court isn't excusing criminal conduct because someone experienced abuse, but judges often look at patterns in a defendant's life to determine whether they're trapped in destructive cycles that keep leading them back into criminal behavior. And here, the judge is openly questioning whether Miss Smith keeps surrounding herself with dangerous people and chaotic situations. The moment where the judge mentions she was shot in the back of the head is shocking. Suddenly, this isn't just a probation violation hearing anymore. It becomes a picture of someone living in constant instability and danger. And yet, the court still has to ask the hard question. At what point does personal trauma stop mitigating behavior and start becoming something the defendant must actively overcome? That's why the judge keeps asking if she's willing to do what it takes to break the cycle, because the court wants evidence of accountability, not just explanations. And viewers, this is where opinions usually split. Some people will see someone struggling to escape addiction and abuse. Others will see repeated criminal choices despite multiple chances. Which side are you on?
And are you willing to keep counseling or do what it takes to not continue this repetitive cycle of self-destruction? Are you asking the judge to continue on probation, extend you at additional conditions, whatever she feels is appropriate, if she decides to do that? Thank you. I have no further questions.
Just very briefly, Judge. Ms. Smith, you were placed on deferred for an offense involving theft, correct?
yes,
And now you're back before the same judge because you committed a theft again, correct?
Yes.
Where the probation officer on their report wrote that you had stopped working. Is that true?
I stopped working because they gave me permission to go to school full time.
But where were you previously working?
CVS, Caremark pharmacist.
What is Heart at Home Senior Care?
Oh, yes, I go to part-time help there.
And what did you do there?
Take care of elderly people, who need their house cleaned, their clothes washed. But that didn't last long because my background came back.
And for good reason, right? We don't want people who have theft offenses caring for people like that, correct?
I've never stolen from a person. I do have a good heart. I wouldn't steal from people.
You were part of an offense where y'all stole from someone who was in a parking booth, correct? At gunpoint?
Yeah.
The aggravated robbery, who was the robbery of?
A tire shop.
But y'all were robbing someone for their property, correct?
Yeah.
And you did commit a robbery in this shoplifting case, correct? Or I'm sorry, a theft in the shoplifting case, correct?
Yes.
The prosecutor's cross-examination here is brutal because it strips away all the emotional context and goes directly back to accountability. No matter what struggles someone has faced, the prosecution's job is to remind the court of the actual offenses and the risk to the public. And notice how sharply the prosecutor focuses on employment involving vulnerable people, caring for elderly individuals while having theft-related offenses. That immediately raises concerns about trust and public safety. Then the prosecutor doubles down by reminding everyone this wasn't just theft. The original case involved aggravated robbery at gunpoint. That distinction matters enormously in court. Because from the prosecution's perspective, this isn't simply a person with addiction issues. This is someone previously involved in violent criminal conduct who then allegedly committed additional crimes while already under court supervision. But then we hit another revealing moment. The discussion about shoplifting, allegedly tied to drugs and personal conflict. This is where addiction cases become so complicated legally and emotionally. Courts see defendants who can appear intelligent, capable, and even compassionate, yet still spiral into criminal behavior because addiction keeps overriding judgment. And now the hearing is heading toward the ultimate decision point: prison or one final structured treatment opportunity.
I'll pass it on.
Were you using drugs at any point during the shoplifting incidents?
Yes.
Why were you shoplifting?
Um,
All right, so what altercation did you get into with your mom?
My mom is very disappointed in the decisions that I made.
No, that's not my question. My question is, why did you get into an altercation with your mother?
Because she wanted me to stay home and I needed to go, fill out the information for school, and she didn't want me to go on that day. She lived far out where there's no bus line. So I needed her to drive me there, and she was on her way to work.
All right, so here's your choice. People cannot write their own programs. If people could write their own programs, we wouldn't be here because everybody would be doing fabulously. Everybody would write their own program. They wouldn't be using drugs. They wouldn't continue to use drugs. They wouldn't continue to use drugs and pick up cases. Or as people say, catch a case. That wouldn't happen. You have. So here's your choice. You can either remain at the Bexar County Jail and go to ISF, Cognitive and Substantive Abuse Track, or you can go to prison for 5 years. Those are your choices. Which do you choose?
Would I be granted my time for 2 for 1?
I'm not in charge of you for 2 for 1 or not, but this tells me where her mind is.
No.
No, I mean, it does tell me where your mind is. So, do you want the 5 years in prison or do you want ISF? Yes or no? I'll deny the motion, alternate amend conditions to include ISF, Cognitive and Substantive Track, and probation. She is not allowed, and I want you to hear me when I say this, and I want you to internalize this. I don't allow people who are on probation out of this court to ever, and people say you should never say never or ever, but in this court, you are never, ever allowed to have employment as a home healthcare provider or any jobs that involve minors. Do you understand? And I don't know why CVS Pharmacy would allow you to be working for them when you have a drug issue. You shouldn't be working around anything that has to do with medications when you have a drug issue. You shouldn't be allowed to be working around any place that has anything to do with medications or drugs when you have a drug issue. So it's going to be ISF, Cognitive Substantive Track. She's to remain in custody until transferred. No employment as a home healthcare provider or with minors. Is there anything else from either side?
No, you're.
All right, thank you.
In the end, the judge made a decision that balanced punishment with rehabilitation, but not without strict consequences. Instead of revoking probation completely and sending Miss Smith to prison for 5 years, the court ordered her into the ISF Cognitive Substance Abuse Treatment Program while keeping her in custody until transfer. That means she avoided prison, but she did not avoid accountability. The judge also imposed major employment restrictions, making it crystal clear that someone struggling with drug addiction and theft-related offenses should not be working around medications, vulnerable adults, or minors. And honestly, that final lecture from the bench tells you exactly what the court was thinking. This was a last opportunity, not a free pass. What makes this case so compelling is that it highlights the constant tension inside the justice system between rehabilitation and public safety. How many chances should someone get? When does addiction become an explanation instead of an excuse? And can someone truly rebuild their life after repeated violations and serious felony charges? One thing is certain. This hearing showed how quickly probation can turn into prison time when new offenses enter the picture. But it also showed that some judges are still willing to offer treatment if they believe there's even a small chance of recovery. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.